Okay, welcome to my weekly show where I take a look at the Twitter feed, essentially, my Twitter feed for the particular week in question. I started this last week. I take a look at my Twitter feed. I see is there anything of use or value or noteworthy or comment-worthy in the whole area of law and business. So let's take a look now. First significant one I noticed there in my Twitter feed is the fact that the Gardaí can now apparently avail of the industrial relations mechanisms of the state in the Workplace Relations Commission and in the Labour Court. This is a new thing, and I think the historic day was last Saturday there. I'm not sure exactly what they can do, and it may be that individual guards can't go. Perhaps it's the representative body that represents them, AGSI and so on, the Association of Garda Sergeants in Ireland. Maybe they have access. Not 100%. If you're a guard, obviously it's going to be of interest to you, and you probably know already, but it's an interesting and historic situation, and it's probably something that was brought in to relieve the tension and the so-called the tension around industrial relations matters, and the fact that guards generally could not avail of the ordinary workplace laws that ordinary employees can avail of. They couldn't go to WRC, for example, complaining about not getting rest breaks or not being unfairly dismissed or anything of that nature, because the law essentially was closed to them. There were exceptions to most of the acts to do with employment law. There's a comment there as well from Sarah Jane Murphy. I don't know who she is, quite frankly. It's a retweet in my feed. She's making a point about the acid attack situation in Waterford. There was an acid attack, a vile attack on somebody apparently, and involving the use of acid. The DPP has decided not to charge the teens over the Waterford acid attack. But a comment that this lady makes, Sarah Jane Murphy, and she's a journalist and she's a born-again solicitor, and she has 16,000 followers. She can be all of those things, but quite frankly, the proposition that she's putting forward there, that the DPP should be a publicly elected position as in other countries, this decision about these teens in Waterford not being prosecuted for an acid attack, it would be a good idea, and that's an absolutely appalling proposition in my view, because you're simply going to have the rule of law being applied essentially by popularity, A, in who gets to be elected the DPP in the first instance, and B, in terms of pressure in making decisions as to the merits of prosecuting particular cases and so on. I think it's an appalling proposition, but anyway, she's entitled to her view and I'm entitled to my view. But the notion of justice being meted out or being decided upon, or prosecutions being decided upon in some sort of a pseudo-popularity context, is unacceptable to me anyway. Saturday, of course, yesterday, or was it Friday, was St. Bridget's Day. A lot of people are tweeting there about St. Bridget's Day. St. Bridget obviously is she's supposed to be from Kildare, I think, and she's obviously the patron saint of Kildare. And in Kildare here, every year you're going to have, or in every house, or most houses, you'll have a St. Bridget's cross. And kids in schools then, my kids, when they were going to the local school here, would have made Bridget's crosses for the Bridget's Day every year, the start of spring. For tweet there about workplace bullying and research. It's always known it could affect your mental health. New research would indicate it can affect your physical health also. So workplace bullying obviously is a very significant problem for some people. And there's a number of avenues, causes of action or courses of action to be taken, including bringing a claim to the WRC, including suing for breach of contract, including suing for a tort or negligently inflicted injury, personal injury essentially, psychological or psychiatric injury arising as a consequence of the bullying. So there's a number of avenues open, but it's difficult enough to prove it, and in the very first instance you do have to show or prove bullying. You do have to prove that there was repeated inappropriate behaviour which offended your dignity in the workplace. And some people are not that concerned about the legal definition of bullying, and they feel that every decision that goes against them, whether they're looking for a day off or an extra day's holidays or a day off to go to a funeral or some management decision or some decision to discipline them, they view these decisions, they view grievances not being upheld and so forth as bullying behaviour, but it's not. It simply doesn't cut the mustard in terms of a legal definition of bullying. There's a tweet there from Mason Hayes and Curran about a social worker who's failed in a High Court appeal against the decision of the Health and Social Care Professionals Council to suspend her following findings of professional misconduct at a fitness to practice inquiry. And that's something that they have a look at there, but obviously that social worker being struck off, it's a serious blow to anybody. It's a serious setback in your career. In fact, it could be the end of your career essentially. But the bottom line is the general public and service users do have to be protected. This person is perfectly entitled to go to the High Court to see or to seek to have that decision of the professional body overturned, but she wasn't successful. See a tweet there as well about a story in the Irish Times where a belly dancer failed in her unfair dismissal action against Dunstores. Apparently, I just had a glance at it there during the week on Twitter or online someplace. She rang in sick and on a particular day, but the supervisor or manager or somebody in Dunstores also knew that on that particular evening she would normally hold a belly dancing class in, I think, a local hotel or function room or something, and the supervisor or manager took it upon herself to go and have a look, or not have a look, to inquire, make a telephone inquiry to see whether the class was going ahead, and the class was going ahead. So on that basis then Dunstores obviously dismissed her on the basis of loss of trust and confidence in the employee, obviously telling a porky, or if she was telling a porky and if she wasn't fit, maybe she made a more remarkable recovery, but she was unable to work because of apparently a kidney infection or something, and she was able to teach a belly dancing class. So you'd have to wonder about that, but you'd also have to wonder that if she did make herself available to work, or if she recovered sufficiently, she would have let the employer know that she was available perhaps to do a later shift or something. I don't know whether that's a possibility or not. But the other, perhaps more important factor is that I think Dunstores have some sort of a sick pay scheme, and this lady would have been paid for her day or paid for the sick day. I think it said that in the article, and therefore she was getting paid as a belly dancing teacher, and she was also getting paid from Dunstores in circumstances where she basically rang in sick. She wasn't able to work, but obviously her actions on that day didn't support that, or so she lost her unfair dismissal claim, and that was on the basis obviously that the WRC, even if they find that a particular procedure that's used to dismiss somebody isn't perfect, they still may agree with the decision, or at least not upset the decision of the employer to dismiss the employee, on the basis that the decision was within a range of reasonable responses by the employer. So a lot of employees come to me and they look to pick loopholes in the particular procedure that was arrived at or used in arriving at a decision to either discipline them or perhaps terminate their employment. And I have to tell them from time to time that perfection isn't actually required from the employer. They do have to afford fair procedures. They do have to follow their own procedure. They do have to give natural justice, as it were. But any little imperfection or infirmity doesn't necessarily mean that the decision to terminate or discipline or impose some other sanction isn't a reasonable one and won't be accepted by the WRC. See, the Law Society there is advertising, or not advertising, tweeting about living with your partner can result in certain rights and obligations under Irish law. That's the case, and I've written a blog post there this morning, or I've beefed up a blog post this morning about the family home, because the protection that was afforded to the family home to a non-owning spouse is also now afforded to cohabitants and civil partners, qualified cohabitants and civil partners, under the 2010 Act, which is the Civil Partnership Civil Partnership and Certain Rights and Obligations of Cohabitants Act of 2010. This is a tricky enough area when it comes to conveyancing, when it comes to buying a property. And obviously relationships can break down, marital relationships can break down, and civil partnerships can break down, and then ordinary cohabitants or qualified cohabitant or cohabitation relationships can break down. And these all lead to situations where solicitors have to be very careful when they are carrying out conveyance on behalf of a client, particularly if they're buying property on behalf of a client. But the tweet is essentially the Law Society have some sort of a guide there about the law covering cohabitants, and that'll be probably useful and worth having a look at. I don't know, quite frankly, whether that guide is available to the general public or not. Presumably it is, given that they're tweeting about it. So if this is something that interests you or is of significance, then head over to the Law Society website, lawsociety.ie, and you might find it useful. There's a tweet there as well, and I actually did a blog post on this myself. It's a very, very interesting case. It's one that involved the pizza delivery drivers for Domino's Pizza. The question arose as to whether they were employees or self-employed. I've written a blog post, and I'm going to make a video about it, but I have written a blog post. I published it yesterday. It's on employmentrightsireland.com. In this particular case, the Revenue Commissioners held that the drivers were in fact employees, and therefore the Revenue Commissioners were looking for money, taxes, PRSI and so on off the employer. The employer appealed the decision of the Taxation Appeals Commissioner and went to the High Court, and the High Court then had to decide whether these pizza delivery drivers for Domino's were employees or employers. This is the first time that a court in Ireland has looked at this question. It has come up in the UK to do with Uber drivers and to do with some other pizza outfit, but this is the first time it's come up in Ireland. The High Court in this particular case, and it's very, very well worth reading my blog post about it, or indeed any other blog post, but the High Court agreed with the Revenue Commissioners in finding that these drivers were the employees of the appellant. Now, there was 4 significant parts to the decision, or 4 significant factors that the High Court looked at in arriving at the decision, including the integration of the workers, including what the actual contract said, including whether the drivers could substitute somebody else for them if they couldn't work on a particular day. And there was one other factor, I can't recall it off the top of my head. Have a look at the blog post. But the critical and crucial thing is that the High Court recognised that there is no statutory definition of employment versus self-employment, and therefore every single case will be judged on its own particular merits and circumstances. And if you are an employer, you need to be very much aware of that. In other words, you may have a contract of employment that says one thing. However, the actual conduct and the course of behaviour between you and the employee or the worker will determine whether that worker is an employee or not, and whether they're employees or not is of huge significance to you if you're an employer and you have to pay a buttload of tax and PRSI and so on. Interesting case, High Court. As I say, employmentrightsireland.com, my website. Have a look at it, and there's a link then to the full decision of the High Court. But the thinking of the High Court and the factors that they look at when it comes to making the decision is important and very, very interesting and useful. See, Byrne Wallace solicitors are looking for a legal executive. So if you're a legal executive, or if you want a career in law, maybe that might be of something that's of interest to you. Have a look at Byrne Wallace solicitors. They're looking for a legal executive to join their busy property team. There's an interesting tweet there as well about a question that was put to a lady running for election. She was basically asked, yes, Senator Catherine Arda apparently was asked by some geezer whether she was going to take maternity leave if she was elected. Yes, the point is being made here by another solicitor that if an employer was to ask an employee, a potential employee, if they planned on taking maternity or paternity leave, they'd rightly find themselves at the WRC. In other words, it would be a straightforward discrimination case, notwithstanding the fact that the potential employee would not have been an employee at that stage. In other words, the question may only arise at the interview stage. Similarly to with Senator Catherine Arda, who's running for election, the fact is that the unusual situation, you can still bring a claim for discrimination to the WRC, even though you weren't successful in getting the job, and even though you are not an employee as a consequence. But you simply cannot ask somebody, do they intend to avail of a statutory entitlement like maternity leave or paternity leave or parental leave or anything like that. It's a stupid bloody question to ask, quite frankly. And, you know, like, I won't say any more. There's another solicitor on there about bereavement leave. He was going on the radio to talk about paid leave for bereavement and paid leave on the death of a child. There's no such right in Ireland, unfortunately. So that's something that people confuse, or at the time they assume naturally that if a loved one is if they're bereaved or if a loved one passes away, then they're entitled to be off for the funeral and so on and so forth, and maybe perhaps get paid. But that's not the case, unfortunately, in Irish law. Maybe it'll change. In the UK, it's a bit more generous, which is very unusual because generally UK law ain't too generous. There's a tweet there as well about the cost of a discovery exercise in legal proceedings, and the recent Supreme Court decision illustrates the potentially disproportionate burden discovery can create for litigants. Don't know exactly what that's about. It's worth having a look, but in general terms, I would say that legal proceedings are expensive, and the discovery process, the procedure by which you can discover information and documents and so on from the other side, can be time consuming and very, very costly. And as Imelda Marcos said when she was talking about being accused of pilfering a lot of money or whatever she was at, $1 million here and $1 million there, and soon you're talking about real money. That's the situation with discovery. It can take on a life of its own, and there's discovery, and then there's counter discovery, and there's affidavits of this, that and the other, and that's where a lot of the costs arise, unfortunately, in legal proceedings. It's unfortunate, but that's the way it is, so you need to be aware of that, particularly if you decide you're going to go to the High Court or any other court. Just in relation to Irish business then, I have another feed there, a stream with Irish business in it, and to be honest with you, the tweets in it aren't great, and I haven't commented much on business, but I see one there where: want to be a successful leader, begin with the end in mind. This is the type of advice that you might say, Jesus, that's great, but if you are starting out in business, or if you're running a business, you should question and challenge everything, particularly question everything, because an awful lot of people will give you what appears to be well-intentioned, is well-intentioned advice about how to start or run a business and so on and so forth. But bear this in mind, one of the wealthiest, if not the wealthiest men in the world is the owner of Amazon, Jeff Bezos. And he started his business, and he said this in an interview himself. He started his business in order to be able to afford, I think, either a forklift or a van or something like that. In other words, there was no huge strategy, there was no huge end in mind, apart from getting either a truck or a forklift. Point I'm making to you is this: educate yourself as best you can when it comes to matters of business. Read books, gather information from people who have done it before, get advice, but question, test everything, and don't take too much for granted. Anyway, that's episode 2 of the Terry Gorry Show, a weekly look at my Twitter feed and legal issues that have arisen in the last week or so. Hope you find it useful. If you do, give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button and hit the bell then, and you'll be notified every time there's a new video. Thanks for watching.